Hello, everyone. I think we have everyone. I might just wait one more minute just to ensure. So just to ensure, I have Isabella Santerre as the appellant, and who is your co-counsel?
Unfortunately, my co-counsel has food poisoning, so he will be unable to attend.
Okay.
Be attending the session tomorrow. However, I did talk to Matt, so he.
No worries, just making sure. I was just a bit confused why there wasn't another name, but no problem at all. All right, I believe we have everybody, so let's get started. So welcome to the Dwella courtroom. Before we begin, I would like to remind all of our spectators that their microphones should remain off at all times. For judges and participants, please keep your cameras on, but your microphone should be on mute when you are not speaking. All present? Session 3 of the Walker Moot Supreme Court is now in session. It is with great honor and privilege that I present Justice Mina Karabit from Wise Health Law, Justice Katie DiTommaso from Cyber Burlak LLP, Justice Katrina Crocker from Bennett Jones, and Justice Amanda Lee from Nelligan O'Brien Payne LLP presiding. Justices of the panel, I present to you, speaking on behalf of the appellant, Ms. Armstrong, in today's matter before the court, Isabel Santerre, and speaking on behalf of the respondent, Dr. Ward, we have Kia Anderson and Renee Taillieu. We are here today to determine the outcome on appeal before the court on the matter between Ms. Armstrong and Dr. Ward. Both the appellant and the respondent's counsel will have 30 minutes in total, 15 minutes per counsel each, to present their arguments to this court, including answering questions from the bench during this time. The appellants will present their arguments first, followed by the respondents, and then a 3-minute rebuttal will follow by the appellant if they choose. I will signal to the court when there is 5 minutes left per speaker, hopefully with a sign like this. Appellants, will you be using your 3-minute rebuttal?
Yes, we will.
Wonderful. The court now invites counsel for the appellant to begin. I'm just preparing my timer, and you may begin.
Good afternoon, Your Honors. My name is Isabel Santerre. Unfortunately, as previously mentioned, my co-counsel, Mr. Jean-Michel Dako, is currently suffering a bad case of food poisoning. However, he did really wish to be here. Therefore, I will present my own arguments, and I will also attempt to summarize my co-counsel's arguments as well. We represent the plaintiff, Mrs. Armstrong. 2 main arguments will be presented to this honorable court. The first of which relating to the standard of care, and the second of which relating to the standard of review. I will address the first point, specifically the fact that the standard of care is a question of execution, not intention, and that causation can be used as a useful tool to determine the standard of care. My co-counsel had the responsibility of demonstrating that the ruling out of non-negligent causes should be a burden for medical professionals when evaluating the standard of care, and he also was going to present our second argument pertaining to the majority's error in applying the standard of review. However, seeing as he is unable to join us today, I will attempt to cover this briefly for your honors today. I ask your honors that you refer yourselves to our factum if precision is ever needed based on these arguments, seeing as my co-counsel was the one that had the in-depth knowledge on these. Now onto the evaluation of the standard of care. The Ans-Cooper test has remained one of the most useful tools available to Canadian courts in cases of negligence. The Ans-Cooper framework highlights the necessary elements of a successful action in negligence and has also been recently used in the 2017 Deloitte and Touche versus Libent case. In this case, the Supreme Court reaffirmed that in a successful negligence action, a plaintiff must demonstrate 4 things. First, the defendant owed him a duty of care. 2, the defendant's behavior breached that standard of care. 3, the plaintiff sustained damage. And 4, the damage was caused, in fact and in law, by the defendant's breach. Now, the Ans-Cooper framework also establishes an analysis in order to determine the prima facie duty of care. However, in terms of an analysis of the standard of care and its relation to causation, improvement and clarity are much needed. Typically, in cases of negligence in which the standard of care is debated, the doctrine of the reasonable person is used. The reasonable person is a concept, as I'm sure you all know, that changes in accordance with each case. In cases of medical negligence, the reasonable person is given the attributes of the defendant, so the standards are higher given the expertise of that person. In cases of medical negligence, it is common practice for expert witnesses to testify what a reasonable person with the same expertise as the defendant would have done in the same situation. In Chanin versus Bell, it was established that the test laid down by the Supreme Court of Canada is a threefold one. 1, the surgeon undertakes that he possesses the skill, knowledge, and judgment of the average surgeon. 2, in judging that average, regard must be had to a special group to which he belongs. From a general practitioner at a rural point, a different standard is exacted than from a specialist at an urban point. And 3, if the decision was the result of exercising that average standard, there is no liability for an error in judgment. It is also important to underline that in Salmon on the Law of Torts, it is stated that doctors, surgeons, and dentists owe to their patients a duty in tort as well as in contracts. It is expected of such a professional man that he should show a fair, reasonable, and competent degree of skill. It is not required that he should use a highest degree of skill, for there may be persons who have higher education and greater advantages than he has. Nor will he be held to have guaranteed a cure. Now, the majority erred in this case in assuming that a standard of perfection was being asked of Dr. Ward, which was not the case. The above stated standard is one that was based in reasonability. A surgeon is trained to work in high-risk environments with precision. Therefore, when it is known that a tool such as the ligature tool can cause an injury to structures within 2 millimeters from it, it is logical that a surgeon wielding that tool should stay away from any other structure. Dr. Ward stated having followed steps to avoid injuring Mrs. Armstrong. The Court of Appeal accepted that Dr. Ward intended to use proper technique and to execute this technique properly in order to demonstrate that he respected the standard of care. It is uncommon in cases of medical negligence that a defendant has missed every single necessary precaution needed to uphold the standard of care and has been intentionally reckless. If a standard of care could be held up by the mere intention of holding it up, no victim would ever be able to ever see justice. Setting up an appropriate standard of care for medical negligence in Canada is of the utmost importance, since the primary goal of torts law is to compensate the victim and the damages for the damages they have suffered. Now, on to my second point regarding the standard of care and how causation can be used as a useful tool to determine the standard. It is important to determine how causation and the standard of care are to be treated. Each element used to prove a successful action of negligence is connected to each other. Is the order in which the steps of analysis performed that important? Can causation be used as circumstantial evidence to inform the standard of care? That is the question to which we ask the court. The above-4 test is usually what is used to determine causality. However, due to the complexity of many medical negligence cases, proof of causation often requires expert evidence. In the Court of Appeal, the majority supposed that the trial judge had used an outcome-oriented approach in which he used Mrs. Armstrong's injury as a means to prove a breach in standard of care. However, in her dissent, Justice Van Riemsdyk established that generally the standard of care must be determined before causation. However, in certain instances, such as this one, it is sometimes necessary to utilize causation as circumstantial evidence to determine if a breach of standard of care had really occurred. In complex cases, the use of causation as evidence can be necessary to fully understand the context and details of the situation. During examination of expert witnesses, various theories regarding Miss Armstrong's injury arose. Some supposed that the ligature device had come within 2 millimeters of the ureter, while others proposed that while carefully maintaining his distance, the ligature device caused scarring through heat dispersion. In order to even determine the standard of care acceptable in this situation, it was necessary to observe the proof of causation, which demonstrated an appropriate distance was maintained. We ask this honorable court to allow the use of causation as circumstantial evidence in determining the standard of care.
So counsel, just to interrupt you on that point, considering how an injury occurred before conducting the standard of care analysis risks reasoning backwards. Shouldn't we be trying to avoid that? And if so, how can you?
Thank you for your question. Now, we aren't arguing that in all cases possible that we should use this reasoning. However, in cases which are complex and the root cause of the injury can cause some confusion, using causation as circumstantial evidence can help see how the procedures occurred during the surgery and seeing if the standard of care was maintained. Though it does seem like a goal-oriented approach, it is necessary in order to fully analyze the situation properly.
Thank you, counsel. I understand.
Now, on to my co-counsel's arguments. I will try to do my best to summarize these. However, if you do have any questions, I would be happy to answer them, or you can also refer yourselves to the factor.
I will just interrupt one moment, counsel. On your first point, arguments, I have a question in terms of, because you're saying that it's not a standard of perfection, but to me, the question is, even if a doctor has performed all the right steps, is it reasonable that they would have potentially made a mistake? So for example, a point that the Court of Appeal had made was regarding dexterity. That even if a doctor takes all those steps, would, a reasonably prudent doctor have the dexterity to perhaps enter within 2 millimeters? How would you respond to that point?
I would respond to that by the fact that that specific surgery and the use of the ligature tool had been done before and by Dr. Ward himself as well. And the likelihood that the risks materialize are very strong in cases where there are anomalies in a patient's body. But in this case, seeing as Miss Armstrong's colon was benign, there were no other structures that were evident. As much as dexterity can be a component, it isn't necessarily a standard of perfection to avoid the ureter by 2 millimeters, because that's what is done in those procedures, and it is what is expected, and what was expected was not reached.
Thank you, counsel.
It's my understanding that didn't the experts even say, and at the trial level, the judge agreed that this isn't a case where this should happen 0% of the time. They didn't want to go that far and still leave perhaps a percentage for a room of error, or for that perimeter of 2 millimeters to be breached without it being a negligent action. So I'm just wondering, do you want the court us to go a step further and say that it's a strict liability case if you breach the 2 millimeters?
No, so as the trial judge and the expert witnesses did underline a certain risk or percentage that it would occur is like 1%, or under 1% actually. We're not expecting a standard of perfection. It's rather the fact that this is a common procedure which should have been low risk, and the risk happened to materialize due to the negligent act of arriving within 2 millimeters from the ureter. If that I don't know if that completely answers your question, but I'd be happy to add precisions if needed.
It does. I just wonder how you account for the fact that Dr. Ward says he stayed 5 centimeters away at all times.
Well, as the evidence does show, and seeing as there wasn't other non-negligent causes that were really brought up, which is actually my following point, it does demonstrate that although he was Dr. Ward was unwilling to say that he came within 2 millimeters of the ligature device, there aren't really other causes that could have produced such an effect and such an injury. Is it okay if I move on to the next argument, Your Honors? Thank you. Now, as we know, in a negligence claim, the burden of proof is placed upon the plaintiff. They must prove the elements of negligence on a balance of probabilities. However, in cases of medical negligence, placing the burden or proof on the victim can be seen as unjust, since the patient cannot usually know the details of how their own surgery proceeded. In fact, the respondent in this case, an expert surgeon, is generally in a better position to know the intricacies of the surgery and all the possible non-negligent causes that could have occurred or led to said injury. In Snell versus Farrell, the court expressed that the ultimate burden of proof is on the plaintiff, but in the absence of evidence to the contrary presented by the defendant, a causal inference can be made, even if positive or scientific proof of causation has not been produced. As a result, it rests upon the defendant to provide evidence to the contrary as a means of defense. Now, evidently this is based in causation. However, it is important to see that this could be used in cases where a standard of care must be established and the burden of proving non-negligent causes should not rest solely on the plaintiff. In medical negligence cases, the plaintiff should have the burden to prove that an act of negligence could have led to their injury, and they should succeed in proving their claim unless the defendant could demonstrate a reasonable non-negligent cause of their injury. So it wouldn't be a complete reversal of the burden of proof, but rather the ruling out of non-negligent causes would be used as a defense by the respondent. The plaintiff would therefore have a legal burden of proof, but the defendant would have the burden of demonstrating non-negligent explanations for the injury as a defense. Similarly, in Austin versus Bubella, the Ontario Court of Appeal determined that a plaintiff was charged with the burden of proof to establish a breach in the standard of care. However, the court also established that the burden can be discharged through circumstantial evidence that leads to an inference of negligence, which then requires a defendant to offer an explanation to negate the inference of negligence. This approach would ensure that the objective of compensating the victim would be possible and that the person with the most expertise could have the opportunity to provide other explanations. This framework would pair well with the complexity of medical negligence cases rather than the current standard. Consequently, giving the plaintiff the burden of proof and making them prove that only negligence could have caused an injury would become an impossible hurdle in many cases. I'll now move on to summarizing the final argument on the standard of review, specifically the majority's error. In this case, the standard of care was, yes, of course.
Time is actually up right now.
Oh, no worries.
Thank you so much, appellant.
Thank you.
The court now invites counsel for the respondent to begin. I'm just preparing my timer. You may begin.
Good afternoon, Justices. My name is Kaya Anderson, and this is my co-counsel, Renee Taillieu. Today, we will be representing the respondent, Dr. Colin Ward. I will begin with a brief roadmap, followed by our submissions. First, I will be explaining why the Court of Appeal correctly fixed the legal mistake that the trial judge made in defining the standard of care as a goal. Second, I will turn to the question of standard of review and why the appropriate standard to be applied is correctness, because the trial judge made a legal error and not a factual error. My co-counsel will then explain why causation should not be used as circumstantial evidence to inform the standard of care. Lastly, she will explain that the Court of Appeal was correct in their statement that the plaintiff can have the duty to rule out non-negligent causes. So beginning with the issue of standard of care, first I will explain how the trial judge erred and created a standard of perfection and why the Court of Appeal was correct in rectifying that error based on the relevant case law. Second, I will clarify the issue of why staying away from the ureter is a goal and not a step. Lastly, I will shed light on why the court must remain extremely cautious in not implementing a standard of perfection in medical negligence cases. So first, at issue is whether the trial judge applied a proper standard of care to determine whether Dr. Ward fulfilled his duty to Ms. Armstrong. Unfortunately, the trial judge erred and created a standard of perfection based on results and not means. The Court of Appeal corrected this error and used the trial judge's findings of fact to find that Dr. Ward was not negligent. So to determine the correct standard of care, one must ask whether the defendant behaved as a reasonably prudent and diligent fellow professional would under the same circumstances, as the appellant has brought up. So the trial judge began his conclusion with these very determinations and found that a reasonably prudent and diligent professional would have taken steps to identify, protect, and avoid the ureter in his conclusion using the expert evidence presented at trial. These steps included checking and rechecking of the location of the ureter, steps the trial judge did find that Dr. Ward followed. And this is what my friend on the other side has referred to as the execution of the surgery. However, instead of using these steps that the trial judge stated at the beginning of his conclusion, he ultimately incorrectly concluded that, quote, it would be a breach of the standard of care for a general surgeon to touch the ureter or come within 1 to 2 millimeters of it, making the standard of care dependent on achieving the goal of not coming within 1 to 2 meters of the ureter. In doing so, he created an absolute duty for Dr. Ward, holding him to a standard of perfection.
Sorry, counsel, I just need to interrupt you on one factual point that I'm following your argument. So thank you for that. But I'm struggling with some of the facts for Dr. Ward. The main point that I'm struggling with is the fact that Dr. Ward's evidence was that he stayed within 5 centimeters from the ureter. However, the injury that we see caused by Ms. Armstrong could only have been done if the ligature was within 2 millimeters of the ureter. How do you address that point?
So I would address that point just by stating that the court is not in the position to fill in these facts. That is left up to the experts. And I think it would be unfair to kind of jump to that conclusion without knowing that that is in fact the only way to cause that injury. And all we can kind of hold Dr. Ward to is the steps he took to not cause that injury. Past that, I think it is a little bit beyond the scope of the court to kind of determine the cause of that injury. So we can see he took the steps that the trial judge outlined and that fellow experts outlined. And we submit that's not touching the ureter, that is not in fact a step, or not staying away 2 to 3 millimeters is not a step, it's a goal. And Dr. Ward took those steps to not achieve that goal.
Would it be your position that either the plaintiff or the trial judge must consider each and every potential thing that could have gone wrong, which could be thousands of things? Is that the reasonable suggestion here? Or should the plaintiff just be limited to proving that a negligent act occurred and then leaving it up to the defense to present alternate theories, which is what they did through 2 expert reports of their own? And wouldn't it be easier on them to raise non-negligible issues in their defense?
Yes, so that is, it's not our position that they would be in a position to rule out every single cause. However, we do submit that that what the experts are presenting to the trial judge is the steps that they would take. And that is not, we're not at that part of the analysis yet. So far, we just have to determine, did Dr. Ward follow these same steps? And with the evidence upon trial, that is what Dr. Ward followed. Does that answer your question?
Thank you. Counsel, sorry, you're getting a lot of questions right now, but
That's
I have
okay.
another follow-up. So please guide me through the standard. Am I understanding that it would be that it's enough to recheck the location? And so in that case, kind of into a slippery slope argument, as long as the doctor's checking the location, they could be waving the device around, but that's okay because that's just a goal to stay away from, you know, any organs that shouldn't be touched.
Right. So I think at trial, it was clear that the evidence of the standard was to check and recheck within a reasonable, within a reasonable amount. That when using the ligature device, you cannot always see every single thing you're doing, but if you are checking and rechecking periodically throughout the surgery, then that satisfied the standard of care in the opinion of the experts. Does that answer your question? Okay, so the applicants propose that the standard of care is not predicated on a goal. However, we submit that this is incorrect because not injuring is the standard of means. And how do you not injure? By trying to stay away from the ureter through the use of periodic checking and rechecking. So we submit again that this is a step that Dr. Ward took. So the case law in this regard is very clear. It is a legal error to create a standard of care that's predicated on a result or a goal. In Filoka and Pinkertons, the trial judge found that any unauthorized person entering the mine that the Pinkertons had been hired to guard would be a breach of the standard of care, regardless of the reasonable steps that the Pinkertons took to prevent that from happening. So the Supreme Court said that the standard created by the trial judge was incorrect because it was an absolute standard. Of course, here the scale is infinitely smaller, but essentially the same mistake was made by the trial judge, that the result or presence of something signaled negligent actions. So it's a very attractive inference to draw because it's deceptively simple. However, case law has remained clear that this inference of negligence is prohibited, especially in medical cases. So courts have repeatedly cautioned about the danger of this inference in medical negligence cases. So for example, the Supreme Court of Canada in Saint-Jean and Mercier, the court cautioned against using the erroneous goal-driven approach described above because it, quote, runs the risk of focusing on the results rather than the means, and professionals have an obligation of means, not an obligation of results. This sentiment was echoed by the British Columbia Court of Appeal in Carlson and Southland, my apologies. In Carlson, the facts were very similar to the facts of this case. The trial judge inferred that because the surgeon had inadvertently cut blood vessels, that a negligence case was prima facie established. So the BC Court of Appeal corrected the trial judge's formulation of the standard of care and reversed the finding. So our friends on the other side stated in the overview of their factum that establishing the acceptable margin of error for medical professionals is an issue that affects all Canadian citizens. An error made during a surgical procedure can severely impact a life or even end a life. And we submit that it's this exact inference that previous courts have cautioned against. It's precisely because medical accidents are so tragic and so emotional that the court needs to be extra cautious and not use them as evidence of prima facie negligence. My co-counsel—
Are there not circumstances, though, in which it would be reasonable to make such an inference?
Certainly, and the Court of Appeal did touch on that, and I believe their examples were things such as the severance of the wrong hand in cases that are extremely egregious. Those are kind of the examples that the Court of Appeal left the door open there for, where immediately upon looking, we know that it is negligence, and we submit that that is not what is occurring here. And those cases are kind of exceptions and not the general rule.
Do you think it needs to go that far to sever the wrong limb, to leave medical gauze or medical tools within a patient for there to be negligence? Does it need to go that far? Or can it be something such as a singed ureter leading to multiple surgeries after the fact and the loss of a kidney?
It certainly can, and I think it certainly can be negligence, damage of the ureter, but I think that is why we have to be very precise in our standard of care, because as lawyers, this is often not our area of expertise. So I think those kind of exceptions are cases where you don't need to necessarily be as maybe intricate in your standard of care because the mistake is so egregious. And I think that is kind of the difference there. So if there are no more questions on this issue, I would like to turn to the standard of review, if that's all right. Okay, so I'll just begin with a brief roadmap for the standard of review. So first I will explain why the applicable standard of review for the issue at hand is correctness. And that's because correctness is the standard of review for legal errors. Second, I will explain why this is a legal error and not a factual error. And third, I will show that the Court of Appeal did indeed apply the correctness standard properly. So to begin, the applicable standard of review for legal errors is correctness. The issue at hand is an error of law, that error being that the trial judge erred in defining the standard of care that Dr. Ward had to meet and improperly established a standard of perfection. It's clear from the case law that the appropriate standard of review for legal errors is correctness, the authority for this being the Supreme Court of Canada, Howson and Nicolason. Also citing Howson, the applicants have proposed that the issue is one of fact, subject to a review of palpable and overriding error. We submit that this is an incorrect interpretation of the issue at hand. The issue is clearly a legal error because it involves the legal component of the standard of care, not the factual findings of the trial judge, which would make it an error of fact. So the factual findings of the trial judge have been respected and shown deference upon appeal. The Court of Appeal accepted the judge's factual findings and even stated that if the error in the legal standard was corrected, using the factual findings of the trial judge, Dr. Ward would be found not liable. So even if the applicants proposed that this was an issue of mixed fact and law, that would be incorrect. Questions of mixed fact and law are questions about whether the facts satisfy the legal tests. Here, the question is regarding the legal test. So Howson highlights this very point, that what appears to be a question of mixed fact and law can be a purely legal question in the circumstances of a negligence finding that rests on an incorrect statement of a legal standard. So simply put, the legal error being corrected rests within the standard of care, not the application of the facts to a correct standard of care. So subject to any remaining questions, that concludes my oral submissions, and I will give the floor to my co-counsel.
Great. I will just begin your timer very quickly.
Okay, tell me when.
Yes.
Okay, so good afternoon, justices. My name is Taillieu, as my co-counsel Kaya introduced, and I am co-counsel for the respondent physician, Dr. Colin Ward. So I will now present our next two arguments. First, I will argue that the Court of Appeal was correct in their finding that the trial judge erred in using causation as evidence to determine the standard of care. Second, I will argue that the Court of Appeal was correct in their statement that a plaintiff can have the duty to rule out non-negligent causes in some cases. So first, I will address the issue of conflating the causation analysis with the standard of care. The trial judge incorrectly used causation as evidence to inform the standard of care, and the Court of Appeal appropriately identified this error. Tort law is grounded on the principle that the elements of negligence must be found sequentially, and that if one element is not proven, the analysis cannot proceed. Thus, causation can only be examined once a breach of the standard of care has been found. Despite his correct statement that courts are required to determine what the standard of care is and whether it has been breached before analyzing causation, the trial judge went on to use the inference that Dr. Ward caused the injury to Ms. Armstrong's ureter to inform the standard of care as being to identify, protect, and avoid direct contact with or close proximity to the ureter. Justice Pacheco in the Court of Appeal correctly identified this error, finding that if the trial judge had applied the correct standard of care, he would not have needed to conflate the issue of causation with the standard of care decision. The use of causation as circumstantial evidence to inform the standard of care has largely been rejected. In an Alberta Court of Appeal case, McCardle, Estate, and Cox, the court stated, "It is a critical fault to reorder the negligence analysis by placing the causation before that of the standard of care. How can a judge decide whether, but for the defendant's substandard action, the plaintiff would not have been injured if the characterization and application of the standard of care decision depends on the causation decision? The suggestion that causation be analyzed before the standard of care is truly putting the cart before the horse. In Befero and Dowd, Justice Laskin explicitly rejected the appellant's argument that the trial judge erred by not considering causation before the standard of care. Specifically, the appellant argued that the trial judge should have made a finding of fact that a burn caused his fistula so that he could then use this evidence to show that the physician breached the standard of care by failing to detect the burn. So similar to Befero, the Court of Appeal in this case found that the trial judge had erred in looking at the cause of Ms. Armstrong's injury to her ureter before determining whether the standard of care was breached. And the Court of Appeal correctly identified this error.
But counsel, isn't it important to know how the injury occurred before you consider a standard of care analysis?
So yes, it is important to sort of look at the injury. However, in our submission, the trial judge improperly used this injury to then define the standard of care as essentially don't cause this injury. So he just reordered the analysis. And I think he put too much weight on the cause of the injury and then defined the standard of care according to the injury, which was an error.
Thank you. Thank you, counsel.
So this error also illustrates the phenomenon of hindsight bias, which manifests in the tendency to exaggerate the extent to which a past event could have been predicted beforehand. Since medical malpractice cases always examine the care of the physician retrospectively, judges and jurors ought to be mindful of hindsight bias when rendering a verdict. Warnings of hindsight bias are well established in the jurisprudence. In Johnson and Hayter, the court stated that the injury itself cannot be a factor used to dictate a finding of negligence, because even though the injury occurred, it could have occurred when the surgeon was using the utmost care, and it is the level of care that is at issue in a malpractice case. In Terneuzen and Korn, Justice Sapinka emphasized that courts must not, with the benefit of hindsight, judge too harshly doctors who act in accordance with the prevailing standards of professional knowledge. For the trial judge to use Ms. Armstrong's ureter as evidence Dr. Ward breached the standard of care was contrary to the warning in Lapointe and Hospital-Legade that courts should be careful not to rely upon the perfect vision offered by hindsight. Otherwise, the doctor will not be assessed according to the norms of a reasonable doctor in the same circumstances, but rather will be held accountable for mistakes that are apparent only after the fact. This error was also—
counsel.
Yeah.
Just in discussing the scope of the correct standard of care here. So let's say the patient wasn't an ideal patient, such as the one that we had before us. Say they had a tumor on their colon or Crohn's disease. Would the same situation not have evidently resulted in a breach?
Could you clarify the question a bit more? Sorry, I'm just—
basically just wondering how far this breach of standard of care goes. So like if they took the same steps that were taken, but there was a presence of an additional factor, would you agree or disagree that there was a breach based on the actions that Dr. Ward took here, but just altering the facts a little?
Right. So I would still submit that there wasn't a breach as long as Dr. Ward took the same steps. As our expert, Dr. Hagen, laid out, Dr. Ward did take all of the appropriate steps that a surgeon should take during a laparoscopic surgery. And I even think that if there were complicating factors of the patient, this would have made our case a little bit easier, because that may have made the surgery more difficult. But we still submit that even though the patient had no complicating factors, that Dr. Ward still did perform all the steps that a reasonable surgeon in his position would have performed. Okay. So this error was similar to one identified in St. Jean and Mercier. where the Supreme Court upheld the Court of Appeals finding that the trial judge erred in using the injury to define the standard of care. Here, the Supreme Court stated that a specific positive act or an instance of omission constitutes a fault is to collapse the inquiry, and may confuse the issue and run the risk of focusing on the result rather than the means. As my co-counsel Kaya stated earlier, professionals have an obligation of means, not an obligation of a result. The error in this case occurred when the trial judge conflated the standard of care and causation analyses, using the result to define the standard. The trial judge used the injury to the ureter, which he said was caused by the ligature, to define the standard essentially as don't injure the ureter with the ligature. I will now be turning
Lisa, it appears that Renee is frozen.
Yes, I just sent a message in the chat. I'm hoping
Okay.
she can see it. We'll just maybe give her a bit of time or.
Sure, did you want to stop the timer?
Yep.
And while she reconnects, I just have one quick question with respect to procedure, because we're dealing with a bit of a different situation here with Jean-Michel's absence. We are going to be ending quite early. I was unclear with how the appellant's argument was going to be delivered. I was under the impression that Isabel would have her 15 minutes and then Jean-Michel's 15 minutes as well. Was I under the wrong impression there? Sorry, Mina is speaking up, but you're on mute, Mina. Mina, you're on mute. We can't hear you, Mina. Okay, we'll keep going.
Mina, if you want to say something, feel free to write it in the chat.
In the chat, okay.
Isabel, would you, I maybe was misunderstood at the beginning. Would you like to take that 15 minutes that your co-counsel would have had?
Okay, yeah.
I wasn't sure how it was going to proceed, so I did try to put the 3 first arguments within my 15 minutes. So yeah, I would love to take a bit more time, but it will only probably be about 5 to 7 minutes more.
No problem. We'll let Renee finish her portion, and then we'll move on to you. And if you want to still do your rebuttal after the fact,
the rebuttal into it, because I can.
Sure, you can do that as well. Yeah, perfect.
Okay. Sure, that sounds fine. I know we're going a bit out of order, and I apologize. I didn't want to put you on the spot, Isabel, if my impression was incorrect and you were not going to be covering your partner's material. But if you are willing to do that, we'd love to hear from you. So thank you, and give you that time, because we have it today. Anyways, Renee, sorry about that.
No, my Wi-Fi took a very convenient time to completely kick me out of the Zoom meeting.
It happens, not a problem. As long as you haven't turned yourself into a cat, I think you're doing okay. So.
Okay, so I'll just restart the last argument since I had only said the first sentence. So I will now be turning to the issue of the duty to rule out non-negligent causes. The Court of Appeal was correct in their statement that the burden to rule out non-negligent causes can fall to the plaintiff in some cases. I'd first like to point out that we aren't presenting this argument in an attempt to overturn the longstanding rule in Fontaine that the burden of proof to rule out non-negligent causes falls to the defendant in the vast majority of medical negligence cases. Instead, we merely agree with the Court of Appeal's finding that in specific situations, such as when a trial judge chooses to proceed on the basis that only negligence could have caused the injury in question, that this burden would fall to the plaintiff. In the case at hand, the application of this finding is somewhat complicated, because if the trial judge had properly conceived of the standard of care to begin with, the plaintiffs would not have had the duty to rule out non-negligent causes. But because the trial judge chose to proceed on the basis that only negligence on the part of Dr. Ward could have caused the injury to Ms. Armstrong, he would have needed to rule out other possible non-negligent causes first. This way, the trial judge would have been properly able to use success as the standard of care. The appellants make the argument that placing the burden of proof on a victim in a negligence case is unjust, since the patient usually doesn't know the details of how the surgery proceeded. Generally, we agree with this point. It is much more difficult for the patient to know what occurred during their surgery than the physician who performed the surgery. That's why in the majority of cases, the plaintiff only has to provide enough circumstantial evidence for the judge to make an inference of negligence, and the defendant has to provide evidence to the contrary. It is also important to bear in mind that it's not the plaintiff, but their expert that would provide the evidence. And we would expect that other general surgeons are capable of providing evidence of possible non-negligent causes. So for these reasons, we respectfully request an order dismissing the appeal before this court and upholding the judgment of the Ontario Court of Appeal in favor of the respondent physician, Dr. Colin Ward.
I just have one question on the non-negligence point. Sorry. This plaintiff had the opportunity, had she believed that there were perhaps other theories of negligence that could explain her injury, isn't it incumbent upon her, if she believes that, to add those other non-negligent parties, or those other parties that are not Dr. Ward? Couldn't she have just added those parties to her proceedings? And the fact that she didn't add them kind of meet that onus that you are placing on her of trying to demonstrate that there's other reasons for non-negligence vis-a-vis Dr. Ward.
Yeah, so if the plaintiff had advanced evidence of other potential causes, I believe there was a brief mention, but it wasn't in the plaintiff's submission. It was just like the dexterity, I believe, was just a comment made by the trial judge. So if the plaintiff had adduced evidence of other possible non-negligent causes, then this would have met the burden. So, oh, okay.
I mean, I just, that point I'm just still struggling with, just because if Ms. Armstrong truly does not believe there's any other reason for her damaged ureter, are you saying, Dr. Ward, that she should be going out and naming other parties and bringing them into this action if they are not negligent?
So it wouldn't have been naming other parties. It would have been just providing evidence of some other possible causes of the injury to her ureter that weren't caused by negligence. So potentially the dexterity issue, or that the injury resulted from scarring, which happens during the surgery. And then the trial judge could have looked at those possible arguments and then made a finding of fact that the only possible way the injury would have occurred is if Dr. Ward negligently came too close to the ureter, and that was the only way it could have been injured.
Okay, thank you, counsel.
I would just follow up, I guess, just ask once more, but why? Like, why would I bring a case? Imagine I was the plaintiff. Why, and I'm advancing one theory of the case, why would I advance every other potential, or bring in unnecessary parties, or burden the justice system in that way, when Dr. Ward is the medical expert? He can account for little things happening or dexterity issues. That's not the plaintiff's case, nor the burden that they have to make. All they have to do is present a case and satisfy it. which the trial judge found that they did. I'm just wondering how
Right. Yeah.
the
So this
defendants
is
feel they
definitely,
can,
oh, sorry.
I was just wondering how the defendants feel that they can, I
Yeah,
guess, opine on the strategy on behalf of the plaintiff.
this is definitely the weakest argument in our case. So we ask that the court decide the case based on the other arguments, which we feel are stronger. This argument was merely addressing sort of a side comment the Court of Appeal made. In my understanding, the Court of Appeal didn't say that she, in all cases, would have had to bring all these other non-negligent causes. I believe it was just sort of a side error that resulted from the trial judge's initial error of improperly defining the standard of care, that if he had chosen to proceed in the way that he did, then the plaintiff would have needed to provide alternate causes. But since the trial judge proceeded in a way that was an error, that in the majority of cases, you're right, the burden is not on the plaintiff to present alternate causes. It's just on the plaintiff to make an inference of negligence, and then the defendant adduces their defense. But I believe the comment of the Court of Appeal was just that, again, sort of like I said earlier, it was just an error resulting from an error, sort of an issue.
So that concludes the respondents portion. So if we want to move back to the appellant, Isabel, I'll give you 18 minutes, so the 15 to account for your co-counsel and 3 minutes for rebuttal, and you may begin.
Thank you, Your Honors, for allowing me this opportunity to continue my arguments. I would like to move on to the standard of review and the majority's error. In this case, the standard of care was well represented by the trial judge. The majority erred by limiting their conclusion on a correctness standard of review without including the notion of palpable and overriding errors. In Housen versus Nicholson, a palpable error described as one that is plainly seen, and an overriding error as one that is sufficiently significant to invalidate the challenge finding of fact. The trial judge had made a conclusion with the facts and evidence presented to him at the time of the trial. By listening to the experts who had all agreed that to meet the standard of care, a reasonable surgeon would have needed to identify the left ureter by locating it on the screen in the operating theater, and then used a medical approach, tweaking it or pushing the structures around it to ensure it moved, pushed away the retroperitoneal structures, including the ureter, towards the head of the patient away from the colonic mesentery, opened the ligature to use it to divide the colonic mesentery only after the previous steps, and to have stayed away from the ureter towards the colon when using the ligature device to divide the colonic mesentery. Subsequently, these steps guided the trial judge's conclusion that the essential element of the standard of care was to identify, protect, and avoid direct contact with or close proximity to the ureter when causing an energy-emitting device like the ligature. Failing to do so would be considered an act of medical negligence by the surgeon, as agreed to by the respondent's witness and Dr. Ward himself. In fact, he did agree upon this. Under cross-examination, Dr. Ward described the standard of care. He stated the standard of care would be to take appropriate steps to dissect structures that are intended. He was then asked, including ensuring that you are dissecting far enough away that if you were using the ligature, collateral thermal damage wouldn't affect the structure, to which Dr. Ward answered yes. Dr. Ward admitted that if he had used the ligature within 2 millimeters of Miss Armstrong's ureter, this would have been an error on his part, but he doubted that he had done so. When asked if he intended to keep the ligature far away from the ureter, he said that he agreed. And he was then asked that if he was mistaken, and he didn't think that he was, but if he was, the ligature, and if the ligature was within 2 millimeters of the ureter, that was an error on his part. He said that anything was possible, but he thought it was unlikely. However, upon repeating the question, it was asked that ultimately his honor is going to have to decide what happened here. And what I'm suggesting to you is that if you did use the ligature device within 2 millimeters of the ureter, if you did it and you still don't know if you did it, there was an error on your part, do you agree with that? To which he responded that he agreed. Now, the trial judge used this evidence when deciding. The so-called overriding error that was presented by the respondent was an error of law, which was using a goal as a step to determine the standard of care. But like stated previously, the trial judge defined the steps that is staying away from the ureter towards the colon when using the ligature to divide the colonic mesentery. It was later determined by testimonies of experts that staying a safe distance from the ureter meant staying a distance of 2 millimeters. With the lack of non-negligent causes presented by the respondent and with the low risks of the procedures, the trial judge had to make a decision accordingly. The majority erred by not demonstrating sufficient overriding errors. This allowed them to incorrectly dismiss the judge's conclusion, which was well supported by the evidence presented at the trial. In conclusion to our arguments, the trial judge's original decision was established by establishing a proper standard of care based on the facts presented at trial, examining the evidence, and by listening to experts' testimonies. The experts, including Dr. Ward, all agreed upon the correct surgical steps that should take a reasonable and prudent surgeon while operating the ligature. This helped demonstrate that the respondent failed to stay a safe distance from the patient's ureter while operating the ligature, therefore causing the appellant's prejudice. Also, accepting the majority's decision on this case would set a precedent that would not only deteriorate the authority of trial judges in medical negligence, but it would also set an impossible to meet standard for victims of medical negligence. We ask this honorable court to restore the judgment set out by the trial judge and restore the right approach and reasoning in cases of medical negligence in Canada. If there are no questions, I would like to move on to the rebuttal, if that is all right.
Just had a question about consent. Obviously, these procedures are not without risk. And one would think that a doctor such as Dr. Ward would have provided Ms. Armstrong with informed consent to the risks associated with this surgery. What do you say about those who say Ms. Armstrong knew the risks of this surgery? She knew that there was a potential that there could be damage done to her ureter, such that her ureter could get singed. And she shouldn't be bringing this action.
What I would like to respond to that is that that argument is definitely viable in situations in which they are high-risk procedures. And Dr. Ward did explain the risks to Ms. Armstrong. However, when he explained the risks were also underlined as being smaller, not likely to occur. So though Ms. Armstrong did take on that risk by going through with the procedure, she had a benign colon and went in expecting low risk, and the risk materialized, unfortunately.
Counsel, but I have a follow-up question to that. So let's say the risk is in 1% of cases, there's a complication. Well, if this case happened to be that 1%, that's still expected, is it not? It might not happen often, but it still happens.
The 1% is used to describe that surgery as a whole, and that 1% should be used to describe people that have structures that aren't normal or malignant, that aren't benign. But in this case, seeing as the patient had a benign colon, she should not have been in the 1% of errors occurring in that kind of surgery, if that answers your question.
Thank you, counsel.
Okay, thank you. Now, as a rebuttal, I would like to take this opportunity to remind this honorable court that the way in which the law currently operates makes it very difficult for victims to be compensated after having sustained injuries at the hand of doctors unless they can prove recklessness. A patient doesn't base their faith on the outcome of a surgery on the means of the doctor in which they proceed, but rather the success of previous operations, and especially with a low-risk procedure like this one, they are not expecting the eventual removal of a kidney. So we would just like to highlight once again that the point of negligent cases and the point of torts law is to be able to compensate the victim. And if this court were to uphold what the majority had proposed in the Court of Appeal, it would make it rather hard for future victims to ever be compensated for further injuries. Thank you.
Thank you so much to everyone for attending. This concludes the matter of Armstrong and Ward. Feel free to enter other competitions to observe your peers. And once again, thank you, an excellent job to everyone who's here. So bye-bye, I'm going to end the meeting now.
Oh, just wanted to say, before you end it, Lisa, just want to say thank you to you guys. Thanks to the folks at Walker Health Moot on behalf of myself and all of my fellow judges here. You guys have done a fantastic job organizing this moot. It's just been such a pleasure to participate. I was in an earlier session this morning and this afternoon's been great. Just want to say we've got a couple of viewers here. Thanks to the viewers for coming and supporting your friends, family, colleagues, whomever. It's always nice to see that that support. I want to say thanks to the other judges. Excellent questions, excellent participation. Thanks for volunteering your time today. It's wonderful to see you guys and see you helping the next generation of lawyers. And want to thank the sponsors too. Just a little shout out to the sponsors. I was in a moot earlier this morning with Dr. Stephen Glazer. So really nice that he's not only sponsoring, but also giving his time as a judge. Really nice. No, shout out to Stephen Glazer, but I am not affiliated with him in any way. And the next step for the judges is we are going to fill out our judging sheets, and we're going to submit them to the Walker Health Moot rather than give you feedback in this sort of forum. So you will hear from us and get some comments from us. We're not going to deliberate, we'll do it independently, but hopefully there'll be some good tips in there. Because we just have a few more minutes, I just want to say congratulations to the students here today. You guys are the real stars of the show. You guys did such an amazing job today. They're in difficult circumstances, right? Not just today, but what you have been expected to do over the past year. So I think you all need to be commended for what you're doing. I can't imagine going to law school in a global pandemic. It's hard enough as it is. So you all need to be commended for doing this. And it's just been such a privilege and a joy to see you all thrive this afternoon. So you've done a wonderful job. Keep it up. Take care of yourselves, because health is number one, but your education is right up there with your health. So devote yourselves to your education now. It will pay off in spades. Say yes to opportunities that arise. You don't have to say yes to everything. The trick is know when to say no as well. But certainly say yes, challenge yourself, take these opportunities. You are all so very talented, and it's just been wonderful to see you. So keep us all in mind, keep in touch with the judges that you see here today. You're all part of our network now. And we just are so thrilled to see you and what you're going to do with your very bright legal career ahead. So thank you all. Thank you to everyone. You all deserve a round of applause. So good luck, everyone, and stay well.
Thanks.
Thank you.
Thank you.
Bye, everyone.
Bye.